Here's a situation that should make any resort condo buyer pay attention. So you bought a condo at a lakefront resort. The deal was simple. You put your unit into their rental pool when you're not using it. They manage everything. You get 60% of the revenue. They keep 40%. A few years go by. The resort decides that split doesn't work for them anymore. So they change it. Now it's 50-50. You get less, they get more. You didn't agree to that, but when you try to rent it out on your own, you find out that you can't. There's a covenant on your title that says your condo can only be rented through the rental pool at the hotel. That's the situation a group of owners at the Cove Lakefront Resort in West Kelowna found themselves in. I'm Mark with Condos.ca and RE/MAX. Today, we're getting into what just happened at the Cove, what the courts decided, and what it could mean if you own or are thinking about buying a resort condo anywhere in the Okanagan or even BC. So the Cove is on Gelatley Road in West Kelowna, right on the Okanagan Lake. This resort features 150 strata units, and everything about it, it feels like a hotel. There's a fully staffed front desk. You actually get a key card for your room when you check in, even if you're an owner. It's got a spa, a restaurant, and a huge family pool with a water slide. The Cove was built as a hotel, not just a regular condo building. When you buy there, you own your unit. But the whole model, it depends on the owners putting their units into the rental pool so that the hotel can function. Now, the original buyers knew the deal. 60% to them, 40% to the hotel. That was the agreement when they bought it. But the hotel operator realized that this wasn't profitable. So they changed it to 50-50. Most owners complained, but they went along with it. But a small group, they said no. And here is where it got complicated. Some owners, they'd never agreed to the new split. But the covenant registered on their title, they said that they couldn't rent it privately either. They were completely boxed in. No private rentals allowed. New pool terms they didn't agree to. Nowhere to go. So they went to court. Now, people who bought there more recently, they already knew what the rental split was going to be when they bought it. So this fight is really about those original buyers, the ones who agreed to one deal and then they got handed a different one. Now, the first big case, it involved one owner named Tor Anderson. He argued that the covenant on his title, it was too vague to be enforceable. Now, the BC Court of Appeal, they agreed with them. They said future buyers, they couldn't read the covenant and actually understand what they were committing to. So the rental terms, they weren't spelled out in the covenant. They were in a separate agreement that could be changed at any time. The court, it said that's not good enough. The management company agreed to discharge almost 20 units at that time. So round two was 2024. About 30 owners, they went back to court asking to have the covenant canceled. That judge said no. Her thinking was practical. If that many owners left the rental pool, the resort, it probably wouldn't be able to provide hotel services. She said that the current owners, they should have known what they were getting into, and it wasn't fair for the owners to walk away from the rental pool, but still benefit from the resort that everybody else was keeping afloat. Round three was the appeal. On February 24th, 2026, the Court of Appeal, it flipped that 2024 decision. The judges said that the lower court hadn't properly applied what Anderson had already settled. The covenant was too vague and it couldn't be enforced. So 28 owners had it declared void. They no longer have to rent it through the pool. So the legal outcome for the Cove is clear. But I bet you're asking, what happens to the Cove now? This is the part that I find the most interesting. The resort needs owners in the rental pool to survive. The front desk, the security, housekeeping, the restaurant, none of that runs for free. It's funded by the revenue that the hotel generates by renting owners' units when they're not there. If a lot of owners pull their units out of the rental pool, the revenue drops. If the revenue drops, the hotel isn't profitable and the services get cut. And if the services get cut, it's not really a resort anymore. At that point, what happens to the value of every unit in the building? Now, the court knew that this was a risk. They acknowledged it directly, but they still ruled the way they did because a bad covenant is a bad covenant. Nobody really knows how this is going to play out for that building, and that's an honest answer. So does this open the door for other rental pools to be challenged? Not automatically. This is how the Cove's specific covenant was written. Courts have already upheld rental pool covenants in other resorts where the language was clear. Panorama Mountain Village is an example where the court upheld the covenant because everything was clearly laid out up front. The Cove's problem was that the covenant on title, it just pointed to other agreements that could change. And that's what made it unenforceable. So if you own a resort condo somewhere else, the question to ask your lawyer is pretty simple. Does your covenant spell out actual obligations on title, or does it just refer to something else that can be changed later? That's the difference. So if you're looking for a resort-style strata unit anywhere in BC, go through these 5 questions with your lawyer before you write an offer. Number 1, what does the covenant on title say? Read the registered document, not just the sales brochure. Number 2, are the rental terms spelled out in the covenant itself, or do they point to a separate agreement that someone can change later? Third, what disclosures did you get up front? Did you receive the actual rental management agreement before you purchased? Number 4, what happens to the resort services if owners start leaving the pool? Is there a point where the hotel model stops working? Number 5, has the revenue split ever been challenged in court? If it's happened once, it can happen again. The original Cove buyers, they got a deal that changed on them. The court said the covenant used to hold them in the pool was too vague to enforce, and now they have a way out. So the big question going forward is what happens to this condo building now? Are these owners actually going to pull it out of the rental pool? I cannot see how a hotel is going to maintain its services if it loses half the units. And if you're looking for a realtor to help you buy a vacation condo in the Okanagan, reach out. You'll find my booking link in the description below. Also, if you want to stay up to date on what's happening in the Kelowna condo market, hit subscribe. I put out new videos every week. Thanks for watching, and I'll see you in the next one.